You're listening to Informed Dissent. If you're a longtime listener, welcome back. If you're new, welcome, and here's the lay of the land. I'm Jamie Reed, a lesbian and a whistleblower who worked inside a pediatric gender center. My co-hosts are Lauren Legere, also a lesbian and a longtime LGBT advocate. Our other co-host is Cori Cohn, a gay man who underwent gender transition early in his life. All three of us come from the left, and none of us fit the story you've been told about who questions gender medicine. And that's not an accident. Every week, we will cover the headlines you need to know across medicine, law, sports, schools, and prisons. And then we dig in. The three of us, and most weeks, a guest worth hearing from. We built this show because we believe that the most important conversations about gender politics are the ones happening between people with real stakes and real disagreements. Free inquiry, honest argument, and dissent that's worth something because it's actually informed. Welcome. Welcome to our Supreme Court ruling episode of Informed Dissent. We had originally planned to release a different episode for today, July the 4th, 2026. But the Supreme Court handed down its ruling on two joined cases, West Virginia versus B.P.J. and Little versus Hecox, on Tuesday, June the 30th. So we're pushing back our planned episode 1 week, which means our very gay discussion, which was going to cap the end of the Pride Month, will now air on July 11th. And to quote Representative Seth Moulton, the court releasing this decision on the last day of Pride was a deliberate act of cruelty towards transgender Americans. So we apologize that we too are apparently taking part in this deliberate act of cruelty by making you wait one extra week for an episode by and about us gay people. Just a short trip down memory lane, this is the same Congressman Moulton who, after 2024's election, told the New York Times he didn't want his own daughters getting run over on a playing field by a male or formerly male athlete. He was tarred and feathered by his own party for it, and now booed at Boston's Pride just weeks ago. He is now in the running for the Senate against a, quote, reliably trans ally. That's a direct quote from Aaron in the Morn. By 2025, he had reversed course entirely, opposing the federal sports ban bill outright. So this man, calling this ruling cruelty, spent the better part of last year as the Democratic Party's designated example of what not to say about this exact issue. We'll leave it to you to decide who's actually been consistent here. Us delaying our podcast episode or the Senate candidate's position on trans athletes. For this episode, we have convened some of the most important voices from the left, the center, and the disaffected Democrats to analyze this case. I, Jamie Reed, will moderate, and at the table today, we will have Cori Cohn, co-host of Informed Dissent, one who has testified in many states on this exact issue, Kara Dansky, attorney and author of books The Abolition of Sex and The Reckoning, How the Democrats and the Left Betrayed Women and Girls. She is a former ACLU senior counsel on criminal justice policy, a former president of the U.S. chapter of Women's Declaration International, former board member of the Women's Liberation Front, current board member of DIAG, the Democrats for an Informed Approach to Gender. She describes herself as a lifelong Democrat. We also will have Kim Jones, co-founder of the Independent Council on Women's Sports, or ICONS, the organization funding litigation against the NAACP over transgender eligibility policy. No, the NCAA. Sorry, not the NAACP. Although they actually put a tweet out about this. She is a former All-American tennis player at Stanford. She got involved after watching young women compete against Lia Thomas in 2022. We will also be joined by Leland Strife, the co-founder and lead organizer of Maine Girls Dads. He's the principal officer of the Protect Girls Sports in Maine's ballot committee, father who relocated his family to Maine after decades in the New York area. He led the Citizens Initiative signature drive that gathered more than 76,000 signatures. I am so excited to welcome this stellar panel. But first, we want to give you a primer and some basics. And we also know that we have a lot of international listeners. The United States Supreme Court is the highest court in the American judicial system. We sometimes will refer to it as SCOTUS. It has 9 justices, 1 Chief Justice, and 8 Associate Justices. There is no mandatory retirement age. We just really like old people staying in office here forever. Justices serve their life tenure, meaning they get to hold their seat until they resign, they die, or they're removed, and no one's ever been removed. That's different from many international high courts, which impose age limits or fixed terms. Justices here are nominated by the president, who's in power at the time of the death or the resignation. That's how it's supposed to work, and then are confirmed by a simple majority in the Senate. Because these appointments are for life, a single presidential term can shape the court's direction for decades. That's exactly why nominations are so politically fraught in the United States. The current court is described often as having a conservative majority and a liberal minority. So we currently have 6 justices appointed by Republican presidents and 3 by Democratic presidents. The framing is useful, but it's imperfect. Our justices don't always vote in pure ideological blocks. Yesterday's ruling was a good example. The court split in its usual way on equal protection, but scrambled that alignment entirely on Title IX. I want to give you a little bit of background on who these justices actually are. So our Chief Justice right now is John Roberts. He was appointed by President George W. Bush in 2005. He's a Harvard Law grad, was previously serving as a judge on the D.C. Circuit Court of Appeals, and has argued dozens of cases before the Supreme Court as a private attorney. He is considered an institutionalist, and he's known to be attentive of the court's public legitimacy. Justice Clarence Thomas was appointed by President George H.W. Bush, the senior Bush, in 1991. He's a Yale Law graduate, the court's longest-serving member, one of its most consistently originalist voices, which basically means he claims to interpret the Constitution according to its original public meaning at the time of ratification. It should be noted that Thomas is Black and is something of a curmudgeon. Justice Samuel Alito was appointed by President George W. Bush, so we're back to the younger Bush, in 2006. He is a Yale Law graduate, a former U.S. attorney, and a former Third Circuit judge. He's generally aligned with the court's originalist wing. Justice Sonia Sotomayor was appointed by President Barack Obama in 2009. She's a Yale Law graduate. We can see they're basically all Yale or Harvard. The first Latina justice and the first Hispanic justice on the court, and a former federal prosecutor and Second Circuit judge. We have Justice Elena Kagan. She was appointed by President Barack Obama in 2010. She's a Harvard Law graduate, former dean of Harvard's Law School, and a former U.S. Solicitor General, the first woman to hold that post. Justice Neil Gorsuch was appointed by President Donald Trump in 2017, filling the seat left vacant after Justice Scalia's death. He's a Harvard Law graduate and the former 10th Circuit judge. He's a committed textualist, meaning he focuses on the plain meaning of a statute's words rather than legislative intent. He's also the one who wrote Bostock. Justice Brett Kavanaugh was appointed by President Donald Trump in 2018. He's a Yale Law graduate, a former D.C. Circuit judge, and a former White House counsel under George W. Bush. He authored yesterday's majority opinion. He also had a rocky confirmation, facing allegations of sexual assault, as did Thomas decades earlier. Justice Amy Coney Barrett was appointed by President Donald Trump in 2020, filling the seat that was left vacant after Justice Ginsburg's death. She's a Notre Dame law graduate, a former law professor, and a former Seventh Circuit judge. She's often described as an originalist in the mold of her mentor, Justice Scalia. She's a Catholic, and she's the mother of 7. And then we have Justice Conjita Brown Jackson, who was appointed by President Joe Biden in 2022, the first Black woman to serve on the court. She's a Harvard Law graduate, a former federal public defender, and a former D.C. Circuit judge. She also famously is the justice when asked during her confirmation hearing to define the word woman. She said she couldn't because she's not a biologist. Here's why these things matter for our conversation today. For our international listeners, yesterday's decision doesn't just settle these 2 individual lawsuits from West Virginia and Idaho. Because a Supreme Court ruling can bind every lower federal court in the country, the reasoning in this opinion will govern how roughly 24 other states' similar laws are treated in ongoing litigation, even though these 2 states were formally parties to the case. That's the mechanism by which a single 6-3 vote by 9 unelected life-tenured judges can reshape our policies nationwide. Now, on to the show. I am so pleased to have this amazing roundtable with us today to discuss the SCOTUS ruling on 2 sports cases that they rolled together, B.P.J. versus West Virginia and Hecox versus Little. To start off with, what are these cases about and what did the courts actually decide? Kara, our legal scholar, do you want to start us off?
Sure. So the state of Idaho, of which Bradley Little is the governor, that's why Little's name is in there, enacted and signed into law Fairness for Women in Sports Act in March of 2020. It's a very clear, straightforward, simple law that says that schools have to keep boys and girls separate for sports purposes. West Virginia did something similar in 2021. The bills are very similar. They're both very clean and straightforward. Male athletes challenged both laws. In Idaho, the challenger is an adult male who has gone through male puberty and was suppressing testosterone. In West Virginia, the male athlete challenger was a minor boy who had had his puberty blocked. In the Idaho case, the lowest court, which is a district court, ruled in favor of the male athlete. In the West Virginia case, this was kind of an interesting twist because the West Virginia federal district judge first ruled in favor of the male athlete, but after getting more of a fuller record, the judge reversed himself and ruled in favor of West Virginia. And the reason that was so interesting is that that judge was appointed by President Clinton. And as far as I know, it's the first time a federal judge appointed by a Democrat ruled in favor of the material reality of sex. I'm probably giving you more than you want, but I'll sum up and get to the end. Both cases went up on appeal. The Idaho case went to the Ninth Circuit Court of Appeals. The West Virginia case went to the Fourth Circuit Court of Appeals. Both courts of appeals ruled in favor of the male athletes. The states then asked the Supreme Court to review those decisions, and the Supreme Court decided to do so. And on Tuesday, the Supreme Court decided that states may maintain single-sex sports in schools throughout the state. In the West Virginia case, the 2 laws in question were Title IX of the Civil Rights Act, which prohibits sex discrimination in education, and the Equal Protection Clause of the 14th Amendment, which the court recognized for the first time in 1971 that women are actually protected under that provision. For some reason, in the Idaho case, the only law in question was the Equal Protection Clause. The male athlete in that case didn't file a Title IX, and I don't know why. Both male athletes are represented by the ACLU, where I once worked, and the male athletes lost in a very strong decision that said that states may, consistent with both Title IX and the Equal Protection Clause of the Constitution, may maintain single-sex sports.
Thank you, Kara. So we have convened this roundtable. So I'm going to moderate. I'm going to read out some of the questions. I want the audience to know that I will do my best to try to indicate to you who is speaking, but I'm going to let anyone on our roundtable jump in with any of the questions that we ask. I think that Kara did a pretty good job of giving us a review about what the cases were and what the courts decided. I think we should briefly touch base on what the actual numerical outcome was. So this was a 6-3 decision, and the majority opinion was written by Kavanaugh. Cori, you gave me a little handshake there about the 6-3-ness of it.
I did. That's because the three justices who dissented actually signed partial concurrences and partial dissents, where they said, we agree with the Title IX portion, but not the equal protection logic. And I think it's fair to say it's actually a 9-0 decision when it comes to Title IX.
Kind of, except for Ketanji Brown Jackson's, like, in her dissent, she actually kind of undermined agreeing with the Title IX. Did you read that?
Yeah,
it was nuts. Yeah. So,
and
yeah.
That's Kim Jones from Icons. So Ketanji Brown wrote her own dissent. Is that my understanding?
Yeah, and I can quote from that. She says, in short, the majority is wrong to suggest that the term sex in Title IX cannot plausibly be interpreted to refer to anything other than biological sex. And then goes on to talk about how a boy can be a girl. So, yeah, did you not read it? Here, I'll read the rest of it.
Ketanji Brown, though, also in her own conferment hearing stated she could not answer the question, what is a woman, because she is not a biologist.
No, right. But anyway, yeah, she says, so I think she concurred on the, so I'm a little confused about her concurrence on the Title IX, given her dissent. Kara, did you read that?
So I have not been able to bring myself to read either of those decisions, because I started with Sotomayor's, and Sotomayor begins with something like B.P.J. is a transgender girl who just wants to live her life as a girl. And
yeah.
Nope, I'm done. I can't do this.
Well, and it's so crazy. I mean, it's actually like, I quote tweeted it or quote posted it on X and was like, this is unbelievable, because it's hard to believe that someone can be this untethered from reality. And to say, she says, Title IX makes room for individuals to live in the gender they choose. As if, again, conflating her definitions of sex and gender and saying we get to choose, and then going on to say, because West Virginia's law forces B.P.J. to live in this case to play as a boy, though she is a girl, it might well run afoul of Title IX properly construed. And I mean, I just don't even know how you get there. Go ahead.
One of the important things I think when we're talking about both B.P.J. and Hecox here is that B.P.J. represents or is a child who is socially transitioned at about 3rd grade. So I think about the age of 9 or 10, was socially transitioned, puberty blocked, and then put on wrong sex or cross-sex hormones. He, by all kind of accounting, this is what happens when you follow the Dutch protocol in early childhood and transition early on. And I originally did find it interesting that they coupled together the B.P.J. case, which his name is Becky Pepper Jackson, with the Hecox case, which is a male who went through male puberty and was on wrong sex hormones only. Kara, do they often couple cases like this together when they're similar-ish?
Sure. Yeah, that was not unusual at all. I mean, I will take this opportunity to say I was slightly worried that the court would rule in our way in the Hecox case, but rule the opposite in the B.P.J. case, because basically, to put it as simply as possible, the ACLU's argument in Hecox is that a man is a woman if he suppresses testosterone. And that was always going to be a completely losing argument before this Supreme Court. The B.P.J. case, on the other hand, the ACLU got to argue essentially a boy is a girl if he never went through male puberty. And I was a little bit worried that the court might be persuaded by that. So I'm very glad that they did not come out that way. The 6 in the equal protection majority very clearly said that male athletes are male athletes, full stop.
Yeah, that was wonderful. Yeah. And can I talk a little bit about the performance of both athletes that are at the center of the cases?
Yeah, absolutely.
So B.P.J. throughout the cases, this is the young, I think when the cases started, he was in middle school, just early middle school. And then now is a sophomore in high school. So second year of high school. And when the cases were going through the courts, it was consistently argued that he always finishes near the end of the pack. He's not really competitive. Like, this is just a misnomer. He just wants to be a part of the team. This is all about being socially included, which also, like, girls have a right to social, especially where sex is relevant, but to just socially say this is for girls and not for boys. So even if sports weren't a part of it, but sports being the center of it, the argument was that he's such a bad athlete and he is so pathetic at these sports that there should be no problem with him being invited onto these teams and participating with the girls just to gain the benefits that they're getting socially out of sports. And then he went and won the state title. So he won the state.
He was in track and field.
Yes.
And when he was at the bottom of the pack, was kind of running, not like
he's not running. He's doing shot put and discus. Yeah. So he's doing power things. But regardless, like, they're lying through their teeth, right? There's nothing. There's no way to make the argument that a state champion is always finishing at the end of the pack. I mean, it's just lies built up. He's not a girl. He shouldn't be eligible. Male puberty doesn't, like, if we go to the science of it, he's been through already 2 male puberties, one in utero, one in infancy. There's conferred male advantage from the get-go. We can measure it from as soon as as babies are out of the womb. Honestly, we can even measure the differences in the womb because they're bigger and heavier and longer and the joints are formed differently. Like, there's no argument that he is anything remotely like a female or going to go through female development. But then that he won the state title as an underclassman blows even their, most, pleading argument out of the water. And then in the case, I think Cori won. I was going to jump on to Hecox and just say, and in the other case, we've got a male athlete who's competed on men's teams, has gone through full male development, then goes on testosterone blockers. And I mean, we've spoken with and, had girls speak out that had to compete against him. And in one case, he was running a leg of a relay on a track. And the girl that he was running next to and passing, or maybe I think he was already ahead of, his coach yelled at him, "Slow down," during competition in order to make it appear less of a blowout against the girls. So, and it was discouraging for the girls. They felt like same story on repeat, just like, what are we doing here? This is absurd. How is nobody stopping this? Where are the people that will see something and say something when it is wrong? And this is abuse, harassment. Girls are getting cut out. He's taking, all these opportunities away. But he didn't just compete in track and field. He also competed on soccer. He was trying to participate on girls' club teams at college. And I think that it's really interesting. So he was kicking girls out at every level of sport in the collegiate level, recreational, club level, and NCAA Division I level. And just the hubris that takes to say, I am entitled, and I'm going to work with the ACLU to say I have a constitutional right as a grown man to participate in women's sports. I mean, it's really hard for me to believe that we live in this world where that had to be taken to a Supreme Court, but it is, a statement on where we are when schools and the NCAA and conferences and so many people are silencing and shaming women when they try to speak up as they're being publicly humiliated. So I just wanted to talk about the differences in those two cases from what the male athletes have gone through, developmental wise and accomplishment wise, how far it's gone.
How incredible that we even need to go through the mental gymnastics as to whether or not somebody has gone through puberty or an adolescent puberty to then make some argument, legal or not, as to whether or not they are a male. I mean, it's absolutely incredible as then girls sit by and watch as you're saying, titles get taken away from them, opportunities get taken away from them because we're all worried about the feelings of this male so much that we're trying to wrap our heads around, denying reality at this point and trying to come up with all these arguments about why maybe reality no longer needs to exist. Oh, because they went on medication and didn't go through puberty. Well, even if that's the case, to your point, through these two cases, like they still have an advantage. And regardless of having an advantage, they're still a male at the end of the day. And there's so much confusion. So I just want to say, too, I mean, to go to the point you were making before as well, Kim, around Ketanji Brown Jackson and her dissenting opinion, too, even in what you were reading, she herself starts to get confused. The constant conflation of sex-based terms and gender-based terms, it's incredible. Once someone has spoken more than one sentence, about it, their entire point of view starts to unravel because they constantly interject both of these terms when, a minute before they could agree gender and sex are not the same thing. But then the second they want to make an opinion about this, they have to be the same thing when it comes to sport or in our case in Maine and many other states as well as when it comes to bathrooms and locker rooms.
So I'm going to jump in and read two of the Kavanaugh quotes here, actually, because I think that these speak really well to part of what Kim was talking about and Leland was talking about. So the first one is, and I think the language is so critical here. He writes, every biological male who makes the team takes a roster spot from a female athlete. Every biological male who earns playing time reduces the playing time of a female athlete. He goes on to say, sports are highly competitive and a generally zero sum. At almost every turn, someone wins and someone loses. I'll say, having been a high school athlete who did not get playing time in a couple of my sports, just being on that roster was a huge deal, and to be able to practice. Kim, I think that he directly takes on and is talking directly to what you have seen about the roster spots, not just the medals, not just the college scholarships, but just to be on that team. Can you talk a little bit about what it meant for maybe some of those girls when you get to make the team?
Well, and so every boy takes the place of a girl. And it's the crazy part of this is like, it is a 1-for-1, right? Like you either make the team or you don't. And we think back about like Michael Jordan played JV basketball, right? If there's no JV team and he doesn't get to play, and every spot matters. It matters in the, the girl who is the last person to make the junior varsity team, even in middle school junior varsity team, this may be what gives her the confidence to overcome a difficult time with her family, a lack of personal self-confidence, a struggle with the physical changes she's going through with regard to puberty and a changing environment. These are important steps and accomplishments for every single individual, and to know that they were judged fairly, and particularly for girls to know that they weren't told to step aside or to be judged by a male standard in something that was set aside for girls and women. So and it's not just the one for one. I mean, I do think that's a really important point to say. You are giving the priority to the boy, and you're saying gender identity is such an important issue for these boys. It outweighs anything a girl could have gone through, whether it was an abusive home or obstacles she's overcoming, or in some cases, some of the girls that we spoken to are hard of hearing and need special signals to even show when a gun has gone off at a track meet. Like, everyone has obstacles, and we have got to stop this worrying about being kind in the oppression Olympics. These are one for one exchanges. But in addition to that, for girls and women, like, when you see as a young woman or even as a mother, a girl not given her rightful place because of a boy, it affects the mental, it's psychologically damaging to every girl who witnesses it. I would also say every guy who is sane, but every girl who sees that has to be willing to swallow and tolerate that they could be that girl, that girls are allowed to be shoved aside, that the mental health and well-being, the feelings of boys, even in things set aside for girls, matters more. It is the most public display of sex-based discrimination I've ever seen, in a developed world.
And I want to bring the dads in here for a moment. So, Leland, you represent the dads. I think there's something also psychological that was happening for the dads as they were watching their daughters in that position too. That powerlessness, that fight.
Yeah, I mean, exactly. I mean, I'm sure similar to moms in a lot of ways, but as dads, we're try to be these strong male figures that are constantly, protecting our daughters and building them up inside of our walls so that when they go out in the world, they can take on the world around them and they can deal with, adversity as they need to, but they can also champion sort of their own battles. And to have additional hurdles put in front of them that knock them down and take those things away is not only heartbreaking as a dad, but I can see that it's something that has lasting effect on them. Inversely, the joy at my 10-year-old daughter when, she made the travel basketball the team this last year. And she doesn't know she was on the team that everyone was on right before that, and then she tried out for the next team. It was her first year playing basketball for the travel team, and they only take 10 girls, and only 10 girls showed up. So she made the team, but her joy at doing that, and then she ended the year as one of the 3 best players on the team because that just set off something in her where she came home every day. She was out on my driveway practicing basketball. It was very cold up here in Maine. She would be in the garage practicing basketball. Like, just the confidence that she had in her at that point is incredible. And now all she wants to do is play basketball at this point. And that is a lasting ripple effect in her life and in other girls' lives. We saw last year there was a male that won the state high jump here in Maine. He jumped in the state finals 6 inches higher than the girl that was given second place. That's a pretty big amount in the high jump. Not only did it displace that one girl that was now given second place, it gave the males team a 1 point lead, because you get 10 points for winning the high jump, a 1 point lead to now claim the team state title, where the girls team was knocked down to second place and everyone else was knocked down the podium as well. So there was well over 100 girls that were affected that day. And I remember a story of a mom that testified in April about this leading up to the states. That boy had stopped competing because of a lot of the controversy. Her daughter had been training for the high jump for years and thought, this is my chance. I might finally have a chance at states. Was working as hard as she could, going to all of the meets. And then the one meet before states, the boy ended up showing up just so that he could qualify for states. And in that one competition, the girl that placed second behind him was a foot and a half lower than this boy jumped to be able to qualify for states. And she talked about the devastation on her daughter's face when she told her that. And her daughter didn't go to states because she was she was like, what's the point? I don't even have an opportunity to win anymore. And I can't imagine for girls that already feel uncomfortable in their body and who they are to then have to go through that. And as a dad, like that makes me emotional even just saying that for her. Like I want to remove any discomfort like that for my daughter, and to know that a girl has to go through that, and that's not only going to affect her that weekend, it's going to probably affect her for the rest of her life. Not okay.
Well, can I follow up again?
Of course, yes.
I feel like I'm talking too much. So having had my daughter have to compete against, Will Thomas in collegiate swimming, and then having a girl say she was a man and join my son's swim team, and where she would not have been able to qualify for that men's team on earth. There's a gratuity spot also for the girl. It's, the harm, the girls go through just belittling, terror in the locker rooms. Like it's a complete erasure of what it means to be female and of the imbalance in physical power, authority. Like when there is a problem for girls, you don't go take on a fight with a 6'5" guy, right? You go to the coach, you go to the administrator. And that's why we have, it's a perfect, example of how society is supposed to work, that when there's something wrong, someone steps in to do the right thing where the imbalance of power is out of sync. But the same thing is like seeing what my son went through. And I think there's some of this is true for the dads, like the helplessness, not being able to do something when you know it's wrong, and that this is a person you have responsibility for. But for the guys, it's emasculating. So when you're in a locker room and you can't, like the girl isn't as annoying in the locker room as a full-blown man is terrorizing. It's like, we'll change with towels around our waist. Like this is just, it's an annoyance, but it is coaching them into, you can't speak up, you can't fix this, you can't do what is right, even when it's an inverse situation. And so, I do think there's a whole lot of, as we have become afraid to speak the truth culturally and afraid to stand up and do what is right, and coached into thinking that giving away rights or turning away from something that's obviously wrong is the nice thing to do, meaning it's the right thing to do. We've really destroyed, discernment, judgment, justice, protection, like right and wrong. We've turned a whole lot of foundational principles that govern the way we function as communities on their head. And that's what I'm hoping the Supreme Court ruling will help, turn that battleship back in the right direction.
That's a great segue to my next kind of question. So what I want to put out there first is maybe for Kara, and then anyone can jump in. What is the actual practical result of this ruling? What does this mean right now in the 27 states with laws in the books and the 23 that are gone the opposite way?
Yeah, it means so that in the 27 states, schools can say to male athletes, no, you're not welcome here. And moreover, we have a state law in the books that protects the female athletes. Too bad. Like that's the outcome here, which makes it a really great outcome. We should talk about why it doesn't help, but it doesn't help those of us who would like to protect female athletes in what we colloquially refer to as blue states, the ones run by the Democrats who don't think women and girls should have sex-based rights. It's my party. But so this ruling doesn't affect those. So California is going to keep letting A.B. Hernandez compete in track and field. Maine is going to keep letting that pole vaulter compete until your referendum is successful. So female athletes in those states aren't protected by this ruling.
So the language difference here, though, so there's a difference between may, M-A-Y, and must, M-U-S-T.
Yeah.
So this ruling is saying that the states may utilize Title IX, but they don't have to, that they must. Explain how that kind of plays out. How do you get a may and not a must?
Yeah, I mean, the court, okay, so these are state laws that protect female athletes and female-only sports. Male athletes challenged them and won at the appellate level. Therefore, the only question before the Supreme Court was, may Idaho and West Virginia protect female-only sports? The question wasn't posed, must Idaho, West Virginia, and other states protect female-only sports? Many groups, including the group I represented in a friend of the court brief, WDI USA, I know Icons did this as well. We urged the court to go further and say, no, Title IX is a federal law. You must protect female-only sports under Title IX. Girls in Idaho don't have more rights than girls in Maine or California. They didn't go there, and I didn't expect them to, and I wanted them to, but courts don't like issuing opinions on questions that are not squarely before them.
Mm-hmm.
And the question I wanted them to answer was not squarely before it. That's not the Supreme Court's fault particularly, although they could have reframed it. They could have reframed it and say, we're going to ask the question, must states maintain female-only sports? And that's what many of us wanted them to do, and they did not do that. Justice Kavanaugh, in the majority opinion, explicitly says they're not addressing that question in this case.
Okay. And I think that was fair, honestly. Yes, we did, encourage them to go there because, and I'm going to take I do think that this ruling, so it doesn't today immediately pull down all of these illegal policies where they're allowing boys to compete in girls' sports. But we got great clarification on what Title IX means and they say it in there. And Kara, you can probably quote it better than I can, but just that sex in Title IX refers to biological sex. And there's nothing else that you could possibly make it up to be. So that's helpful. And it's also helpful that equal protection is, that these laws work under equal protection. They don't violate equal protections. So these precedences, this decision does apply to all of the girls and women across the country on a recognition of Title IX is a federal law, a recognized federal law that applies on the basis of sex, and that laws, that follow that guidance are constitutional, and they have the right to be there. So using this precedence, we have 3 federal lawsuits going on to strike down policies that were being used by the NCAA, that conferences and schools have been allowing at the collegiate level, allowing males to compete and participate on girls' sports and to enter their locker rooms. So we need cases brought before the courts now that pull in the questions around Title IX and protection to say, are those policies and laws in violation of federal law, so that they can be on the offensive? And I think that's what Kara was trying to point out. This was a defensive situation where the ACLU and these boys were trying to pull down their laws.
Good sports terminology here, Kim. This was a defensive move and not an offensive move.
Yeah, there you go.
Okay, there we go. Okay.
Am I right, Kara? That's what you were kind of trying to lead into?
Yeah, it's just that this decision does not automatically help, for example, female athletes in Maine or California.
Yeah.
All of this is going to have to be litigated, I'm sorry to say, but it just is. Kim's, Icons lawsuits are going to have to go forward. Another great example is Connecticut, Seoul versus CIAC. This is a great offensive case in which 4 female athletes sued the Connecticut State Athletic Association, alleging that the association's practice of allowing male athletes to run in girls' track and field violates their rights under Title IX. Unfortunately, that case is now 6 years old. It's been pending before the federal judiciary forever, and it is still stuck in front of the original judge that it was before in 2020. We don't have to get into that now. But if that case makes it to the Supreme Court, for example, or one of the ICON's cases, those will be good avenues to argue that not only may states protect single-sex sports, but states must protect single-sex sports under both Title IX and the Equal Protection Clause, because anything else is unlawful sex discrimination against women and girls.
All right, Leland, I'm going to have you jump in, and then I'm going to pitch a question about our friend of the court, Thomas, this time.
Right. Yeah, I was going to say, while it's a sobering reality and unfortunate that it doesn't enforce change in Maine to the points you guys were making, Kim and Kara, it does at least give us permission and precedent as we move forward. The fact that, the law that we want to put in place to our referendum is lawful. A lot of the opposition that we end up hearing is that, we cannot designate all these sports and private spaces in our schools on the basis of sex because we're changing civil rights laws and we're discriminating against people by doing so. Well, from what I understand, these decisions today emphatically say from a federal standpoint the opposite of that. No, this is constitutional. We are providing equal protection to everybody because everybody has a sex, and we're not starting any discrimination. In fact, we're ending sex-based discrimination that continues to happen in all of our schools right now. So I think it gives us not only permission, but a lot of the language as well to, I hope, actually allow other people to come into the tent as well. I think there's a lot of people that sort of understand from a common sense standpoint that sex should be prioritized, but think that they've gotten wrapped up in sort of the mainstream media's perspective that you're part of creating discrimination against trans people if you're on this side of the issue. And no, the Supreme Court has said not at all. 9-0, you're actually standing for federal civil rights that have existed for 54 years. And, from 6-3, from a perspective of also offering everybody equal opportunity since everybody has a sex. So I do think there's a lot of positive permission that is going to give us some headwind and momentum, at least in Maine, and I would assume in a lot of the other states as well.
I like that phrase, positive permission. Okay. Clarence Thomas and Dennis Kavanaugh kind of came out in this ruling as kind of the spear throwing running heroes here, which was a little bit strange. Thomas
Cori's making a face. I want to know why.
Thomas said something that I think he went out on a limb a little bit more than the majority did. So he argued that transgender status should not get heightened scrutiny at all, and described gender dysphoria as a, quote, immutable mental state rather than an immutable trait, and wrote flatly that sex is an immutable biological characteristic and that it is binary. This was one of my interesting takeaways. I mean, basically, in layman's terms, Thomas is basically saying this is a mental illness, and that does not make it one for heightened scrutiny. Any other Thomas or Kavanaugh takeaways or favorite quotes? Go, Cori.
Well, I just want to mention that part of what you quoted from the Thomas's concurrence is actually him quoting our friend Alex Byrne.
I heard this.
Right. So that's
interesting.
exciting.
Yeah.
And Alex Byrne, if you don't know him, he's written on this in the academic forum about gender and the language that is used for describing these things. But he was also a member of the HHS study on the transgender review for the medications. So it's pretty exciting to see his name. Could I just mention one thing around the 14th Amendment equal protection arguments that they have? So before any of these cases ended up hitting the Supreme Court, the ACLU built its whole strategy on transgender rights around equal protection arguments. And those have been knocked down one by one, leading all the way to this case, to the point where this particular opinion cites Skermeti, which was issued last year about the medicalizing children, saying that states have they have a reason to pass these laws They have a valid reason to pass these laws that are based on sex. And so while there might not be a good, clear definition of sex in law, each one of these opinions is making the definition of sex clearer and clearer in such a way that the next case that the ACLU brings is going to have a harder and harder time making that equal protection claim. So I don't know, Kara, if
Do you think
I'm not a lawyer, but I'm interested if I'm on the right track here.
Yeah, I think that's totally right. Can I just say something quickly about equal protection?
Go for it.
Because it helps us understand. There was a law in place in Idaho that had nothing to do with any of this. It had to do with the administration of probate estates and who got appointed to administer an estate when somebody died. And there was a case where a young man died without a will and he didn't have any children, and the administration of his estate was going to go either to his mother or his father. And this law in place said blankly, or, just flatly, it said, in deciding who should administer the estate, males should be preferred over females. It just said it. It didn't provide any reasoning. It just said, just because males should be preferred to females. And so the judge did what he had to do under the law and gave the administration of the estate to the father. And the mother didn't like that, so she challenged it through the state courts. And then a young lawyer named Ruth Bader Ginsburg heard of the case and got involved and essentially took the case all the way to the Supreme Court in conjunction with the ACLU, which in 1971 knew what a woman is. She'd founded the Women's Rights Project. So she takes this case to the Supreme Court and she says, basically, listen, Supreme Court, women count as people under the law. That was the first time the court had been asked to apply the Equal Protection Clause to women and girls as a sex class, 1971. And she won unanimously. And the court said, you know what, you're right. Women are people and are entitled to equal protection of the law. So that is sort of what all of this jurisprudence is based on. It was based on Ruth Bader Ginsburg persuading an all-male U.S. Supreme Court that women and girls are entitled to equal protection based on an Idaho law that explicitly preferred males over females. So that's just some context. We didn't get here for no reason, right? It was like through the very hard work of people who have argued over the years. And Ruth Bader Ginsburg ended up authoring a decision when she was on the bench in 1996 called United States versus Virginia that said you can't have a federally funded all-male school. She's sort of the champion of all of this. Sorry, I'm getting over a cold. So this is Ruth Bader Ginsburg's legacy. I guess that's what I'm trying to say. This is Ruth Bader Ginsburg's women's rights legacy, and the ACLU wants to shred it for males.
This actually made me think, yesterday a quote kept running through my head, which was the arc of the moral universe is long, but it bends towards justice. And I kept thinking, did we go on a weird bend where we tipped the wrong way and now we're coming back around? Because it seemed like, we are having to bend over backwards to just go to the plain material meaning that sex-based civil rights protections were built in the first place to protect sex. Backwards and moving forwards. The long arc right now, I still hope is continuing towards something, but
I think we're in a pretty precarious place right now, actually. So while the judgment, I just don't think we want to pat ourselves on the back too much with the judgment yesterday. We finally have a big ruling that and I want to go back to Clarence Thomas also said that girls and women are members of the female sex class. And I loved seeing that in writing. And boys and men are members of the male sex class. We shouldn't have to say that, but I was glad to see it in writing. Anyway, there's the talons of insanity are in really deep right now. And there is, I don't know that we're going to get one of these other cases that Kara was referencing up through the federal courts, up to the Supreme Court, before there is a good chance, of our electorate remaking our Supreme Court into a kangaroo court. And that's definitely the threat all over the left-hand side, is that we want to remake, rebuild, and reshape the judiciary, which is going to, our whole judiciary system. And that's where we are right now, having trouble. The legislative process isn't working to protect what we see as the federal rights that are, recognizing women as people too. The legislative process in states is broken. The judiciary process is broken in states. We're like holding on by a thread here for this most foundational aspect of communication between people and, the survival of the species, for heaven's sake. What is a man and what is a woman? So we have issues to face over, getting more court precedents, getting the public to, and I do think court precedents is incredibly important in giving the public freedom to speak about something and not feeling like, oh my gosh, is this illegal? It was 2.5 years ago when I was trying to speak in a California library that they shut down the speech and said, you are not allowed to call someone a male athlete. It's against state law and it's against federal law. And it's silent. That threat was effective at silencing 90% of people at that time. Thank heavens Kara was walking me through this. And I think that there's a huge risk. We're at a kind of a teeter-totter or precipice moment right now where it's going well, but if we fall off the edge of this, it's going to be really hard to ever claw our way back. And the enforcement aspect of this is being challenged. How are you going? We know how we could, having worked with, IOC folks and USOPC folks and helping to write sports policy, it is not difficult to write an enforcement policy that is cheap, effective, and where we can screen everyone. And we have to know everyone's sex in order to do that. But we have enforcement, we have judiciary threats, and we have, just capture in an ideological sense of so many of the institutions that are grossly outfunded relative to us.
Yes.
That are fighting. So we've got a long fight still ahead.
All right, let me walk you guys through where I want to go with our next kind of series of questions. So these are the things I want to touch on. I want to touch on whether or not this ruling actually dealt with any of the evidence presented on the hormonal interventions, any of the athletic advantage, what the science said, how they were sort of drawing on Scarametti. So we'll do that first. Then I do think we need to talk about Gorsuch and Bostock. I think it always keeps coming back up. I think it needs to be discussed. Let's talk about the dissents a little bit, and then we'll blow out to our wider frame and wrap up. So to start with the science, I felt like there was a lot in this where the court did accept some propositions. Biological males generally present inherent physical advantages, height, weight, strength, speed, endurance, jumping ability, and the like. I think that they still kind of keep saying that the science is not settled over some of the medicine that was brought up in Scarametti. Cori, you're nodding. Did you kind of feel like they're still saying, we don't know about this part?
I think when you read Sotomayor's dissent part of her dissent concurrence, one of the things she brings up, I think fairly, is that the question about equal protection was settled incorrectly in her opinion because it didn't give any analysis of the individual's circumstances. It just said there's men and women. And in the opinion itself, it's recognizes in a couple of places, we don't even have to get into the evidence because, in fact, men are men and women are women. And this is not about how girly these medicalized boys are. This is about understanding these as distinct sex classes. So there really is not any deep analysis of the evidence. And the court says we don't need it. We don't want it and we don't need it. Only Sotomayor is saying, I think we should actually look at the evidence more.
Didn't the court also basically say that they don't want something like who has to make that determination? Like individual judges shouldn't have to decide,
That's
were
right.
you on a puberty blocker long enough, and then were you on hormones this amount of time? That's just too much in the weeds, that there's just this blanket category and we'll just stick with that. Was that what they were pretty much saying? Yeah.
Yes. And
Yeah, that would be totally unmanageable. Can you imagine? Like, that would just be utterly ridiculous. So I think they're kind of right on that. I did think Justice Kavanaugh did a fairly decent job of making the points about male advantage in athletics.
He also wrote a beautiful section about, basically what it means to participate in sports as a girl. You get
Yeah.
up early, you put in the hours, you do the work. I mean,
Yep.
I
Can
could,
I say something about
Yeah.
Justice Kavanaugh? And first of all, you called him Dennis Kavanaugh, who is a lovely British male turf ally.
Yes, that's exactly who. Not you, Dennis. Sorry, he's probably listening. Thinking
No,
I'm
it's
not on the Supreme Court.
Brett Kavanaugh and Clarence Thomas. I just want to say there are some ways in which I don't love this outcome, but for the most part, it is a very solid win and worth celebrating for female athletes. It's weird because the two best opinions, in my opinion, are written by Kavanaugh for the majority and Thomas in concurrence. And I like Thomas's even more than I like Kavanaugh's, which is saying something. But I do just want to say these are both male judges who have been accused credibly, in my view, of sexual misconduct. And I just want to make sure that that's clear and we're not brushing that under the rug. At the same time, it does us no good to deny that these are very strong opinions that protect female athletes and the material reality of sex, and that it's the female judges who have thrown women and girls under the bus.
So that brings us to the dissents. So all of the dissents were written by 3 liberal female justices. And I saw a poll within our own small group before the ruling came out on Tuesday. A number of people saying, I hope it's going to be 8-1, a lot of 6-3s. Is this hard to swallow? Do you have feelings about the fact that these are not just 3 of the women on the bench, they're also younger, they haven't been on. I mean,
well, Kagan's been on a while. I had a slight hope for Kagan because as a former academic, I think she likes to think of herself as intellectually honest. I had no hope for Sotomayor or Jackson, but I did have some hope that we might get Kagan because of that, because she thinks of herself as an intellectually honest person. And both of these opinions, one authored by Sotomayor and one issued by Jackson, I think Kagan signed on to both of them. She definitely signed on to Sotomayor's. There's nothing intellectually honest about those opinions. And we probably shouldn't refer to them strictly as dissents because, as Cori alluded to, they're partial concurrences and partial consents. So we can just call them opinions.
okay.
Yeah, I have strong feelings, but I'm not sure. Like I just can't believe that we're here. I can't believe that my strong opinions are more though that I think these women right now are just making a mockery of the judicial system. Like the same way I think a lot of these opinions are making a mockery of the medical community. I mean, or the sports community when we get policies that allow this stuff. Because it is insanity. So to get people willing to, these judges have teams of individuals reading the amicus briefs, reading the science that was presented. They also, you would think when you get to that age, should have a couple, brain cells working on common sense. And none of that is on display. And so when Kara says like, it's not even intellectually honest, like frequently when someone asks me, why do you care so much about this? Like, isn't this a tiny little issue and it's being overblown? No, like the reason why this matters, and we do polling in different states where on people, like 90% of people who are polled say on a scale of 1 to 5 that of relative importance that this is a 5. And it's a 5 because this is the lowest bar we can get to judge whether or not people can be like functional. When you can talk in basic terms, I can communicate with you. I can trust that you are not going to try to deceive me with what I see right in front of my eyes. It's the lowest possible bar. So when we have justices sitting on the Supreme Court with these crazy degree credibilities, like everything gets thrown into a I don't trust it, realm.
So Kim and Leyland and Kara and Cori too, I wanted to ask, part of this is, how does this feel for you? Because this is not just okay, I read in the news the Supreme Court ruling. There's something very personal and impactful about the amount of work that you do behind the scenes day to day to bring you to this ruling. And one of the things I'm hearing you say, Kim, is that it's so important, but at the same time, we're fighting something also that feels, as Kara has said before, so ridiculous and stupid. And how are we at this point that this is what we're arguing about? But you've all spent years being told that your position was the position of the bigot. That you, Cori, are you raising your hand? I'm the bigot?
No, I want to actually read from Kavanaugh's opinion.
Sure, go ahead.
And this is on page 27 of the opinion. Second, we do not accept the dissent's assumed monopoly on understanding the effects on individuals involved in disputes over transgender athletes. We are acutely aware of the difficulties sometimes faced by boys who identify as girls and by girls who identify as boys in middle school, high school, and beyond. And we greatly admire the desire of all students, including transgender students such as B.P.J, who want to participate in sports. But in conducting the equal protection inquiry, we must also account for the effects on girls who are forced to compete against biological males in sports. So I wanted to read that whole thing, but focus on the first part.
Yes, reread that first part.
We do not accept the dissent's assumed monopoly on understanding the effects on individuals involved in disputes over transgender athletes. So this goes to your question, Jamie. We're kind of put in the role sometimes as being the bigoted or aggrieved or reactive parties. But the opinion itself says we reject that framing. We have the ability to have sympathy for everybody who's affected here, and we've just come to different conclusions. And that is how I feel. I think we all do. We feel a lot of grief for the children who are being told by adults, you have the ability, you have the potential to become a member of the opposite sex, and we are going to enable that. And they are being loaded up like a pistol magazine with the entitlement to go and violate the rights of typically boys violating girls' rights. But we are not heartless. We do care about all of these individuals. But the fact that we are focusing on the girls who are affected instead of the boys who are being elevated by this ideology doesn't make us villains. It means that our sympathies cannot be equally applied. They are being applied to the invisible group.
Well, can I just add to what Cori was saying there? I agree completely. I feel like it's also saying we're not going to be emotionally manipulated anymore. Like, we know we're on the right side of this, and this is sort of the court speaking for all of us and saying we are not going to let your name calling manipulate us into thinking we are somehow in the wrong here.
You know it's important when I have to get a pen and write it down, Kara. Leyland, Kim?
Well, I mean, I was going to say, I think, yeah, to that point, I think that's heartening, and I hope others continue to speak up. I mean, I can say for myself, I haven't been in this fight as long as you guys have. It's been about a year and a half of my time at this point, and I've started to see the effects of being able to speak up and use accurate language, and what that means, and how that could, socially and professionally ostracize you from people. I think that, to go back to one of the things you were saying as well, Kim, is that being, excited, happy about the decisions that came out of the Supreme Court of the United States, but understanding that there's such a long road to go and that we're at such a precarious point. I think for me, that's a lot how I've been feeling through this as well. And I think that the three dissenting opinions of the female judges is telling on that as well, is that it feels daunting to me. It feels overwhelming at times. And I think just really daunting of the insanity that we are up against. Things that seem common sense, things that seem accurate to other people seem like they're living in an alternate universe. And I think, even up here in Maine, Jamie, we've talked about this, the primary opposition that we have up here in Maine and is led by the Maine Women's Lobby, that hired the Mark Elias Law Group to try to take down our referendum and get it off the ballot so that people can't vote on it. I find these things hard to believe. There was just a interview I posted with her the other day where she continues to say this is a manufactured crisis and we have laws that have been working for 20 years and we have evidence to show that those laws work really well here. I don't understand. I joined testimony a month ago where girls talked about masturbation and voyeurism and losing out on sports. This doesn't make sense to me. So while we can change laws and we can be emboldened to use the language that's accurate and correct, until culture changes, which you can't just enforce culture through legislation, it's a pretty long road, I think, to clawing back a lot of these institutions and these people that are in positions of power intended to protect girls that are actually doing the opposite of it right now. So I think, I see a silver lining and, maybe a break in the clouds with some sun shining through. I guess, for me looking at it with, a lot newer to this situation than a lot of you, I guess, some of my naivete is falling to the side and I'm looking at it saying, wow, there's a big hill still to climb, but it feels like maybe yesterday helped us sort of, get to base camp on that journey to the summit.
Yeah. Kim,
Yeah.
I'll go to our final question.
Yeah, I resent the framing so often happens, for political points or for wanting to take a victory lap of look what we did. It's all tied up, and this is just a final deciding, because we're so not there, and that's so deceptive because it takes the edge off of the public who has come to an awareness of just how bad this is, to be like, oh, now I can be complacent and I can just, I don't, somebody else took care of the problem and I don't have to enter the fray. And it's like, one thing I don't think people realize is, no, everyone is going to have to cross this Rubicon. There isn't, you don't get to stay on the other side in a comfortable place. Even you can wait until a whole bunch of other people have gone ahead of you, but there isn't a way to not take a position or just say, I can be complacent or apathetic about what is reality and what are the laws and what can I be required to say? And does our judicial system work? And are people able to enforce the rights of, I will say, like little girls? When it comes to sexual abuse and harassment, public humiliation, like this is a very weak culture, weak civilization that can't do that. We're looking at we scoff at how backwards and terrible cultures are that, sell children into marriage or, openly sex traffic children, or that don't let girls go learn how to read at school. And or all kinds of terrible practices. And yet that is happening and people are afraid to say no when it's happening in public view here. And if we have a culture or a society that's complacent about that or apathetic towards it, we've lost our moral backbone.
Can I say one thing in follow-up before going on to the last?
Yes.
I kind of wanted to follow up on what Leyland was saying. I think it can be exceptionally difficult when you're new to this for two reasons. One, because everything seems so completely crazy, you can't quite believe it's happening. And two, you can't quite believe that you can put a bunch of female athletes in front of a body and have them say, this is happening to me, and then have someone else say, this is just a manufactured crisis. Like that seems like it should be impossible. But the thing is,
ultimate gaslighting. It is ultimate gaslighting.
But the thing is, everybody has to understand. Everybody has to understand that if you are on the side of denying the material reality of sex, you can say anything you want all the time because you are confident that you will get away with it. And that's what they do all the time. And we all have to also understand that everything is as bad as it seems. I mean, it really is. It's hard to believe. And I know Jamie wants to finish up, but sometimes I refer to this as like, this is our society being in an abusive relationship with an abuser. There's all the manipulation, all the gaslighting, all the terror, all the authoritarianism, and no one wants to have to wake up to the reality that we are in an abusive relationship. It's hard to do that. I've had to do that in my own life. It's very uncomfortable. No one wants to think that we've had the wool pulled over our eyes or whatever, but we have to do it. We have to understand that it is just as bad as it seems.
So for my final question, this episode is going to air on the 4th of July. So on Saturday, where we here will be celebrating the 250th anniversary of our independence and our breakaway from the UK. But right now, we are seeing two different common law systems that were based on something similar are both now starting to converge and land on that same material floor that Kara just referenced. So for the women in Scotland versus the Scottish ministers, that was a unanimous holding that sex, man, and woman in the Equality Act meant biological sex, full stop. That gender recognition certificate or not, that there is a material reality to biological woman and biological man. And now we see the second Supreme Court ruling in the past 24 months, Skermeti and now B.P.J. Hecox, where we see the language also coalescing on this side that there has to be a legal recognition of the material reality of sex. My question is this: what has to change fundamentally about our culture to allow what we're seeing really start to solidify in law? Let that become reality. My answer myself to this was that the media yesterday showed me very clearly that it is still going to be one of the biggest hurdles to overcome. What do all of you think the next steps are for our two nations to make what the law is starting to say is correct become really reality?
So I completely agree with you that the media is one of the biggest problems in this. And one of the ways in which the media has been so problematic is propping up the narrative that this whole fight is between what I put in air quotes by saying the big bad Christian right and a small marginalized community. That is the narrative that has prevailed for the past decade. And it's not true, but it makes people on the left, frankly, scared to speak up because we've got this current administration and no one on the left wants to be seen as allied with Trump. I understand that. I just don't care anymore because I'm too far in this. Like, I can't stop speaking up. And if someone wants to call me a Trump-aligned bigot, I just don't care. Like I've never voted for the guy, right? So we've got to keep breaking in to the media and raise our voices, raise the LGB Courage Coalition voices, raise the Icons voices, raise WDI USA and Wolf, and get people to understand that you can be on the political left and still know what a woman is.
Thank you, Kara.
Yeah, I mean, mine is probably similar as well. I mean, what I continue to see is this is increasingly not a left or right issue, that this is just a common sense issue, especially when it comes to parents. This is people with brains issue, and those people are on the right side of this. And I think that what I'm seeing, and I've taken even from you guys, because you've been on this a lot longer, that courage really begets courage. And seeing you guys speak up and, other dads speak up and use accurate language in a courageous way where, I could see myself in that and say, man, I could do that too. And I know that if I do it, another dad is going to be able to do that and someone else is going to be able to do that. And I think that to me is maybe the most important thing. There was so much power in, calling people bad names a year or two ago that doesn't exist anymore. We now have court cases that talk about, biological reality. We have all of the ingredients that we need to be able to speak up. And we have an administration that is incentivizing, corporations to no longer inject this stuff into their corporate culture as well. It has been removed in a lot of ways versus if I had said, if I had tried to do this while I still had my job at, the largest professional services firm in the world 2 years ago, or 3 years ago, there's no way I could have been able to do it. So the only reason I was able to even start doing this while I was still, working was because it was aligned to what the administration is trying to do. So thank God we have an administration that is pushing change in corporate culture, but it's up to us now to start really being courageous. And I'll at least just speak from a dad perspective. There's not enough dads that are showing up. There's a lot of moms, there's women, and there's girls. My heart breaks every time I see these, press conferences in California, for example, with 15 girls standing up there and at their podium talking. And then behind them is a bunch of women, and there's like one dude in the back somewhere. Like, where are dads and men speaking up about this? Because I know we all are in our house and we're all telling our daughter, you can do anything, I'll do anything for you. And then we go out there and we don't say anything to anybody. We're scared that like we're going to get fired or my neighbor's going to think I'm a bigot. I mean, my neighbors don't even wave to me anymore. Like, who cares? If I'm not here to protect my daughter, literally, what the hell am I doing on this earth? If I'm not here to be the same dad in my house as I am on the street, literally, what am I doing? Like, I'm not a person of integrity at that point. I'm not a father at that point. So I think at least from that perspective, like, grow a pair, and start speaking up, because that is the only thing that's going to change, not only I think for culture at large, but for your daughter. And we know that our examples shape the world of our kids.
Yep. I'm going to echo that 100-fold. I think, having had a bunch of kids going through college recently, I don't think there's anything good about the education coming out of these institutions. They're literally about teaching these kids to tear down everything foundational to our society that has kept us afloat, that has allowed us to make the progress we've made. They're not even teaching basic history. They're not discussing. Everything is about feelings and, preferences. I mean, there's classes in there about how the family is a destructive force, literally at the Ivy Leagues, a whole class on talking about how a traditional family is a force for destruction. Everything is upside down. And so all foundational systems are being attacked. And when I talked earlier about this being a low bar, like, if we can't cross this, if we can't determine and say women and men are different and they have unique needs and experiences, and our society is going to be structured to recognize that, we can't do anything, people. So we all have to get to the point where Kara is. Everyone has to get there where you say, I don't care. My goal is to get to the truth and to try to do what's right and to build up what's good. Otherwise, we are out of luck.
Leyland said something that I think is accurate, which is that this is not a left versus right issue. But I will say that it is an elites versus non-elites issue. And one of the biggest reasons why people are afraid to speak up on this is because they are either in an elite class or they aspire to gain entrance into the elite class. And their lack of principles and their aspirations to enjoy the good society of all the well-thinking, right-thinking people glues their mouths shut. So to the extent that you have been raised to recognize injustices when you see them and to speak out against injustices when you see them, that gives you an ability to speak up on this issue. But to Kim's point, the more that these kids are being taught that these types of values of recognizing justice that are, this is conservative, it's too traditional, we don't need these types of values in our kids. It just makes it easier for these types of ideologies to take root. I know when I say that, and now it starts to sound more conservative versus progressive, but I really do think that if you go and I live in a working class neighborhood, I could knock on every single door in my block, and 90% of the people would say, no, boys should not be competing with girls, and no, we should not be transitioning kids. They're not the elite. But if I went to the richest zip code in my city and I did the same exercise, it would be flipped. That's just how it is. So unfortunately, if you want to be aligned on this side of the issue, you have to risk your participation in the elite class. And I think, Kara, if I can reinterpret what you're saying about other people's opinions of you, you don't care if people regard you as being a member of the elite anymore. And I don't care if I don't want that either. So come join us. There's more of us.
I want to just one last thing, what Cori said, like just the going back to, we just don't care. Like everyone, this issue tests your threshold, I think, of can I do what's right, or can I be compelled to do what's wrong? And so it's a personal test of your moral clarity and your ability to tolerate discomfort in order to stand up and do like the most basic thing. So it's a test. And we'll see what way we end up here. We'll know in the coming years.
I just want to thank all of you for taking time today to join our listeners, to read a Supreme Court ruling in its entirety, and to just be those who are willing to stand up. So thank you so much for your time today.
Thank you, Jamie.
Thank you.
This podcast is produced by the LGB Courage Coalition, a registered United States nonprofit fully funded by small donations like yours. We work to promote evidence-based medicine, ending the medicalization of gender nonconformity, and advocating for LGB rights. Supporting this show means supporting that work directly. If what you heard today mattered to you, please like, subscribe, and pass it along. Word of mouth is how independent shows like this one survive. You can reach us in the Substack comments section or by email at lgbcouragecoalition@gmail.com or through the contact page on our website at lgbcourage.org. We want to hear from you. And until next week, stay informed and ready to dissent.